Hello viewers, this is your Nisha Fasanla. Viewers, I initiated this channel with the objective of discussing the exam-oriented important legal questions, especially for law students. Additionally, at the end of each video, I'll also explain two important legal terms by which I'll assist you use them confidently and grow in your legal career. Okay, without further ado, let's go to see our today's video. Our today's video is all about the infringement of patent under the Patents Act 1970. Through today's video, we will cover all of these areas. First of all, we will know what the infringement is, then types of infringement, doctrine of equivalence. Here I put stars, right? This is because this is very important question. We can even expect for this semester. It can be asked under the 4 mark or sometimes 7 mark questions. These all we can cover under the first part, then provisions for patent infringement and reliefs granted under the Patents Act will be covered under the next part, that is part 2. Okay, let's move to see what is infringement. These all are key words for our better understanding. Infringement usually occurs when a third party who is not a patentee uses, sells, makes any patented product or process of product without the consent of a patentee. Here, this consent also refers license. The license can be divided into two types. One is voluntary license and another one is compulsory license. This is also an important question. We will cover it in our upcoming video. Let's move to the types of infringement. There are two types. One is direct infringement. The another one is indirect infringement. Under direct infringement, different than that is third party directly copied the product of patentee without obtaining the consent from him. So this infringement is also known as literal infringement. Then we move to the second type, that is the indirect infringement. This indirect infringement is covered under the doctrine of equivalent. I already mentioned, right? That's a very important question. Further, the indirect infringement is also known as the non-literal infringement. With the help of the Venance vs. Tenmate case, I'll explain the doctrine of equivalent. For a better understanding, let's see first of all the facts of the case. Venance, a plaintiff manufactured a burden car to transport coal easily in a cylindrical shape. Later, Tenmate also manufactured a similar burden car not in cylindrical shape but in octagonal shape. Here, Venance filed an infringement suit against him. Tenmate argued that his product has not been copied as he used a different shape, but the court held that though the shape is different, the purpose and function are identical to the Venance product, hence it amounts to infringement. Further, the court also upheld that the infringement occurs merely by changing the form of invention. Hence, even if there is a minor or small change of the form of invention, it also amounts to the infringement of patent. This doctrine further developed in the case of Graver Tank versus Linde Yar in the year of 1950. Under the test of triple test, there are three criteria. If any accused product satisfies these three criteria, then such product also falls under the infringement. Okay, I'll give you an example for our better understanding. A manufactures a variety of tablet to cure headache in round shape. Later, B, by using same way of A's product, that is a tablet, with the objective to curing the headache, not in round shape but in oval shape. Okay, let's connect this example with this test. First test is substantially same function, it means same category. What the category of A and B's tablets are, both comes under medicine, hence the first test is passed. Then the second test, substantially same way, the process of making tablet is also same, hence the second test is also satisfied. Then finally third test, substantially same results, it means usage, Both are being used to cure headache. Hence, this amounts to an infringement. Further, there is one more important test, that is all element test. It is upheld in the case of Warmer Jenkinson Corporation versus Hilton Davis Chemical Company. Here the court held that each claim separately and not to the invention as whole. I'll explain this sentence with the help of Winant's case. Here in the case, Winant claimed separately. He claimed for function and object, and the Denmead defended against the shape. But just imagine if Winans claimed for whole, that is for all invention, including the shape of his product, he would definitely be defeated, right? But he claimed separately, and court also accepted and held in favor of Winans. So this is about the doctrine of equivalent. So now this is the time to know the important legal terms, right? Okay, now in this video we will I'll explain two legal terms. One is patent. This patent is defined under this act itself. Section 2 subsection 1 class M of the Patents Act defines a patent for any invention granted under this act. So we can take a patent as a recognition of something along with exclusive rights. Here something means any invention. So here our second legal term explanation is invention. So invention is also defined under section 2 subsection 1 class J of the Patents Act 1970 itself. When a product or a process of product involves novelty, inventive step and capable of industrial application, such product or process of product is known as invention. So these are all two important legal terms for today. Please use those words in your day-to-day life also. Okay, I hope you understand this video well, and if this video useful for you, please do subscribe our channel. Thank you.